Suliman Carrim is not in this room, and that empty chair is about to cost him a criminal charge. He was ordered to appear, ordered to testify. The chair's ruling of the 29th of July gave him one way out, one independent medical assessment by the 12th of August. He never took it. Instead, 2 days before the hearing, a report lands from his own treating doctor, stamped, strictly private and confidential, medical privilege invoked, not for dissemination. Then the chair says out loud what nobody expected. We do not consider Mr. Carrim's doctor to be an objective expert. A doctor who, the chair says, appears to have shifted the goalposts. Because first the doctor said a patient can only leave the facility if I allow them to go out. Then came the Woolworths trip, the Kauai trip, and suddenly even nurses do allow patients out. Then the hammer. The commission will lay criminal charges against Mr. Carrim. Because otherwise, the chair warns, witnesses will come or not come willy-nilly, and we cannot and we will not have that. Nothing is proven, nothing is decided, but the charge is coming. Like, subscribe, tap the bell. Let's go inside.
The ruling is quite clear, the ruling of 29 July. In clear terms, what it says is that Mr. Carrim is required to appear and to testify today, and that he may only do so if he is excused on the basis of an independent medical assessment.
He may only not do so.
So he may only not appear.
Yes, you left out the not.
Thank you, Chair. So he may only not appear today on the basis of an independent medical assessment, which was to have taken place by the 12th of August. Immediately following the ruling, the evidence leaders took steps to obtain the names of suitable independent specialists who could attend to the task. We provided the name of such a specialist to Mr. Carrim's representatives the day after the ruling. That's the 30th of July. On the 31st of July, we received a response from Mr. Carrim's attorneys saying that they had forwarded that information to the family and to the treating doctor. You'll recall, Chair and Commissioners, that the ruling required that if there is no agreement on the proposal from the evidence leader side by the 3rd of August, that then the president or the chair of the professional association should nominate an independent specialist. So we heard nothing further from Mr. Carrim's attorneys. And so we wrote again on the 3rd of August, the deadline, requesting a response by 10 a.m. on the 4th of August, especially a response as to whether Mr. Carrim has consented to an independent medical evaluation, because we were concerned with putting things in motion and putting people out unnecessarily. We also indicated in that letter of the 3rd of August that if we didn't hear back from them by 10 a.m., that we would then contact the president of the association in order to set things in motion. No response was received on the 4th of August. We approached the president, who nominated a specialist. And we thank the president of that association for responding to the commission's requests with urgency and providing us everything that was required. And we regret if there was any inconvenience caused. The president provided us with the details of the independent specialist. This was communicated to Mr. Carrim's attorneys on the 6th of August. It was only on 12 August that the evidence leaders received the treating doctor's report, the report that Mr. Permit has now referred the commission to. And so the report provides to us, for the first time in this process, a detailed explanation of what is said to have occurred following the ruling on the 29th of July. whatever may have been occurring between Mr. Carrim and his family and the treating doctors, none of that had been communicated to the evidence leaders while we were attempting to give effect to the ruling. The report essentially is an opinion by the same treating doctor as to why Mr. Carrim could not consent to an independent medical evaluation, and it provides further material information regarding, clinical information regarding his condition. Notably, it says nothing about the outings that we referred to in the postponement application, the daily outings by Mr. Carrim. There is reference to the 14 July excursion to Woolworths and to Kauai, but and that's for the purposes of complaining that it had become public, that it had been made public.
Is the answer to that not possibly that that was dealt with in the postponement application, even by the treating doctor?
Well, it wasn't dealt with in depth by. It wasn't dealt with from the perspective of what the meaning of that is for Mr. Carrim's inability to testify now. And that's what we are concerned with now, is the current condition in the light of these daily outings. I would have expected that would have been addressed more fully, given that it was a significant aspect of from the evidence leader's side, the opposition to the postponement application. But that's not the main, that's not it. The problem, the difficulty we have also with the report is that it's a lengthy report that's furnished 2 days before the hearing without any opportunity for the evidence leaders to obtain a considered expert opinion of the contents of the report. As the Commission is aware, there is an independent specialist that the evidence leaders have consulted and would have otherwise wanted to consult on this. But the report is expressly marked strictly private and confidential, medical privilege invoked, not for dissemination, and that it is furnished strictly and only for the consideration of the chairperson, commissioners, and the evidence leaders. That places us in a difficult position because it's prepared at a level of clinical detail, and it says so. The doctor at this time says the last reports were for a layperson. This report, he says, is prepared at the level of clinical detail that's appropriate for consideration by a medical professional, but the restriction that's imposed upon its dissemination makes it impossible for us to obtain, for our own purposes, any independent assessment from an expert of that report. So where we find ourselves now is in this circular process, and we keep going around the mulberry bush with respect regarding this witness. And at the time remaining for this commission, and this is the submissions I'd like to make on how we'd go forward, Chair and Commissioners, there's limited time remaining for this commission to complete its mandate. At this point, we submit it's appropriate for the commission to simply make its findings based on its assessment of the evidence that's already before the commission in the previous hearing at which Mr. Carrim was present, and the evidence that's been provided, and also, for that matter, on the basis that there's certain information that has still not been furnished. The Chair is now familiar with the basic information that we've requested on just financial statements. That hasn't been forthcoming in the interim since the postponement application either. So what we would submit is that the Commission now just makes its findings based on the evidence that it currently has without any further...
What kind of findings do you have in mind?
And let's live with that, is what I'm proposing.
Yes. And what is to be done about the issues that the evidence leaders consider to be still outstanding? There's nothing that can be done in that regard. Conclusions will just be drawn in whatever way regarding those outstanding issues?
Yes, the witness hasn't been able to make himself present to address any of that, and the Commission should follow the normal course as it would in any other hearing in the absence of answers to draw its conclusions.
So if the outstanding matters tell an adverse story on their own without anybody speaking to them, then the Commission may draw whatever inferences in that regard.
Indeed so, Chair. That would be the normal course in any hearing, even in a court. So that's what we propose should happen going forward, except for the following, which I'd like to add as my final submission, and which is that we do request that the Commission records the non-attendance and refers this non-attendance and the record to the NPA or the relevant authority for further consideration for potential breaches of the provisions of the Commissions Act and the regulations. Chair, and the reason for that is that the Commission, through its ruling, has given Mr Carrim a fair and objective route to establish medical unavailability. He chose not to opt for that route. The ruling is clear that the witness may only be excused on the basis of an independent report, and we don't have it. It's not a finding that's going to be made by the Commission. It's a finding that will lie elsewhere, but it needs to be referred to the relevant authority for potential violations of the Act. Those are my submissions, Chair.
Thank you, Ms. Hassim. Mr. Premier?
6 very brief comments in reply, if I may, please, Chair. The first one just relates to timing. I'm surprised to hear my learned friend complain about the fact that the 12th of August gave them insufficient time, whereas in Chair's original ruling from the 29th of July, had Mr. Carrim participated in the independent medical examination, that report was always going to be delivered by the 12th of August. And so to latch onto the date...
That was not Mr. Carrim's doctor's report.
Correct. Correct.
So I don't get your point.
The point is simply to say that the 12th of August was always a line in the sand, that the commissioners had itself identified that the status of Mr. Carrim would be known or not known, even flowing from the independent medical exam report.
I still don't get the point. You're talking about a different report, and the report in the ruling was to have been a different report. So I just don't get your point.
Correct.
At all.
All I'm saying is that, of course, the report was going to be different. That report was going to be pursuant to the independent medical exam. I'm not quibbling with that at all. But what that report would have done is it would have clarified Mr. Carrim's status to participate in the commission by the 14th on the 12th in any event, because he would either be excused as a consequence of that report delivered on the 12th.
Ms. Hassim is making a different point. She's saying they were not given sufficient time to decide what to do after a different report. Not the report that was expected. A different report was given at the 11th hour. That's a different point altogether.
I'm willing to accept that we submit, which is that when the outings, and I'm using that in inverted commas because they're not outings, there is a clinical explanation for that, and the Commission has the medical report in front of it. But let's use that term, even though it carries a certain connotation.
Maybe it doesn't take us anywhere, but
I think Chair has the point.
I'm interested to know what your idea of outing is when you say outings, but these are not outings. From where I'm sitting, they appear to have been outings.
Be that as it may, in front of the Commission, and they stand as an explanation for those outings,
you see,
one way or another.
Last time, and I will repeat even now, last time when you made a similar point about these reports not being challenged, I said to you, how do you expect them to be challenged when Mr. Carrim is resisting, strenuously so, to be examined by somebody who can actually challenge those reports. So it's a non-starter for you to talk about a lack of challenge.
That's
Complete non-starter.
I respectfully disagree with you for three reasons, and this is my third comment. In the first instance, the doctor has himself made himself available on more than one occasion to the Commission.
Mr. Carrim is indeed unable to come to this commission. The Commission has said it wants to have him assessed by an independent specialist. He has refused that should be done. That's the assessment that the Commission wants to have. It's not an assessment of Mr. Carrim's specialist. That's the simple point I'm making.
Yes.
And for Mr. Carrim to offer us his specialist, that does not assist. In fact, that actually takes us to what courts always say, the hired gun principle. Because from where we are sitting, we do not consider Mr. Carrim's doctor to be an objective expert. He is an expert that's closely associated with Mr. Carrim, and who, from where we are sitting, unless we get another opinion, appears to us to be pushing Mr. Carrim's story. So very close to, if not analogous to, what courts have referred to as a hired gun. In this sense, if a court wants to get an objective view, it will want to get someone who is independent, as opposed to someone who's closely associated with the person concerned. And this is exactly what we have here. A medical specialist who has been treating Mr. Carrim for this lengthy period, and who on certain facts appears to have shifted the goalposts. And why do I say so? I say so on the basis of that paragraph that I referred to during the postponement application. In fact, I referred you to more than one. There are the paragraphs where he changes his story on factual issues, not issues related to Mr. Carrim's condition. On factual issues, he changes his story because he said a patient can only go out of the facility, only, underline only, if I allow them to go out. But once we got the Woolworths and the Kauai visits, all of a sudden, the doctor now changes tack and says, oh no, actually, even nurses do allow patients out. So from where we are sitting, those are indications that this is a doctor who has so aligned himself with Mr. Carrim that sitting, I'm not saying he's lying. All I'm saying is, sitting where we are sitting, we just cannot accept what he says. We do want to have an independent assessment, which we do not have and which we will obviously never have, because this same doctor strenuously resists that. And it is best known to him why he does so. Of course, he does explain in the reports that he has given. But from where we are sitting, we cannot just accept that. So it is on that basis that I say, in accordance with jurisprudential authority, his position is very much analogous to that of a hired gun. And it's in those instances that courts always insist on someone who is independent, someone who is objective. But as I say, we are not going to hold our breath on in that regard. We're not going to have such an independent assessment. So I say again to you, you cannot say that You cannot respond to my point about the lack of contradiction in the manner in which you do, because that opportunity has been refused. I know I've said a lot, but respond anyhow you want to.
No, I'm indebted for the indulgence to respond. I am cautious, however, that I'm not going to take us in a circle regarding this contention, because that if whatever your reason is to doubt the objectivity of the expert put up, in the particular instance of a medical examination, you cannot leapfrog that evidence and that practitioner to go directly to the patient.
Why not?
Because that's going to be my second response to you, because then that takes us into the V-raise issue and whether or not you have the power to do that in the first place. So what I'm saying to you, Chair, in response to those three things you said about it could be any reason, he's associated himself with the case, and that's the basis for the concerns about and that you don't agree with the staggered approach that we're talking about. I'm willing to accept that, but I respectfully disagree with you, because not only does it leapfrog what we submit respectfully to you is the correct sequence having regard to what happens in the High Court, we also say that there's a V-raise challenge potentially to the extent to which you can make such an order and compel such examinations and proceedings.
There's no compulsion, and I'm not even sure that the virus issue that you say you are going to argue, and on the basis of which you are talking leapfrogging, even arises. There's no compulsion. It says I think
it says voluntarily.
Exactly. Yeah. So if he chooses not to go, nobody will force him.
Yes.
So the virus issue really does not arise at all. I know I've gone to your next point, which you have not argued on, but because you've already mentioned it, and nothing stops me from dealing with it. So this virus issue, from where I'm sitting, simply does not arise at all. So
a supervening medical impossibility, but be that as it may, if Chair is, and I think we're ad idem on this actually, if Chair is not going to attach any punitive consequence or coercive consequence to the election in the voluntary scenario.
Let me upfront tell you what I am, or rather what I think the Commission should do. The Commission is minded to refer Mr. Carrim for a criminal process. What the relevant authorities do in that regard is for them to decide. Whether it's taken to the South African Police Service for them to see whether they can lay charges, or the National Prosecuting Authority for it to see whether to prosecute. That's their decision. That is what the Commission, as we are sitting here, is minded to do.
Yes.
So that will not be coercion by the Commission as such. It will be those functionaries who have the power to do whatever is within their remit to decide or do.
Correct.
That's what we are minded to do. So that you are not arguing in the dark.
Yes.
Let me upfront tell you what we are minded to do.
No, I'll deal with that. That's my last point, which I'll deal with about any such referral. So I'll come to that if I may. I just want to deal with this voluntary nature of the choice that was made. And I want to clarify that I was not suggesting that the voluntary choice given in paragraph 2, particularly paragraph 11, if such a recommendation is going to be made, then on that specific question about whether criminal charges should be recommended or not recommended, all I'll say is that our client, as far back as the 24th of June, asked that if such a referral was or recommendation was going to be made, that he be given the chance to address specifically that referral decision consistent with authorities like Dupree and so on. And also, because that's an Audi issue, we say respectfully, and particularly to place in doubt the question of willfulness and whether or not such criminal charge is competent and viable as against my client. However,
sorry, but
apologize.
aren't those issues, that is the issues of willfulness and so on, issues that should actually arise before the relevant criminal authorities? If that referral does not get killed at the level of SAPS or at the level of the NPA, they may then be dealt with by the criminal court. So I'm not sure I get your point.
What I was going to say, and then rightfully I showed deference to the chair, is that on that particular point about Audi in front of you before the recommendation, I was going to say that's not the hill I'm going to die on, because it might be correct that you can make the recommendation being recommendatory in nature without ticking the box of direct external legal effect as well as adverse consequence, that you even owe us the right of Audi at that stage, because the correct decision-making functionary is where we'd have the ability to make those representations anyway. So what I was going to say to Chair is that the request is in front of you. You may choose to say no, which is fine. I'm just saying that the request is there. That's all
we are all here now. Make whatever submissions you have in mind in this regard, so that we are done. It's done and over with.
Thank you, Chair. May I just make 3 submissions in this regard then? Number 1, the test would be willfulness for any such breach or non-compliance. We say that the threshold is not met, having regard to the medical evidence that is in front of you, and which is unchallenged. And I know that that's sensitive territory, so I tread lightly. That's the first point. The second point is that the point about that evidence being unchallenged, so to speak, and where non-compliance is as a result of medical advice as a valid and legitimate excuse, is actually something recognized by the foreign authorities that my learned friend Ms. Hassan handed up at the last hearing. You'll remember I was going to do an audit of those authorities, and then Chair intervened and said, no, maybe we can leave those authorities. And we did, and I never went on to those authorities. But can I just give you the single reference to the one authority, please, that is in my learned friend's bundle? And I just want to point it out, because I say that that's the second basis upon which we're entitled to utilize. It's the England and Wales, I think it might be Court of Appeal, EWCA. No, it's the Administrative Court, I apologize. EWCA Civil Division 1040. At the bundle that was given to you by my learned friends, you'll please look at paragraph 21, where the conclusion reached by the court in that regard is that where a litigant was unable to attend through no fault of his own, must usually be accommodated, however inconvenient, and then goes on to say it would be absurd to criticize a litigant for not attending to give evidence on his condition when the doctor has advised him that on medical grounds he should not attend. That's at paragraph 25 of that same authority, and in the paginated bundle you'll find it between paginated pages 31 and 33 of that bundle. So that's the second reason, Chair, that there's authority to say that there is a valid exculpatory reason which has been given. And the third one, Chair, is to say that conduct. Then I don't think I could have an Audi objection, because that's as good as, and I'm going to abuse Ms. Matlingwane's name next to me, that's as good as if I went to the police station and laid a charge against Ms. Matlingwane for intimidation, which is probably coming very soon. She's a very good junior. But I don't owe her a right of Audi. I accept that. That's why I was saying, however, if the secretary is going to write to the SAPS to say, I am recommending that you SAPS charge Ms. Matlingwane with intimidation, and that flows from an ex officio capacity.
Let me right away say, if what I said, the commission is minded to do does eventuate, it will not take the form of a recommendation. The commission will just lay a charge.
Yes,
so I think we should just step off this idea of a recommendation.
No, correct.
And let's move on.
Yes, because
that will not eventuate.
Yes, because that also takes me to my original point, which I apologize for that if that's my doing. So, but I'm indebted to you, Chair. May I just take an instruction?
And Commissioner Baloyi has a question.
Oh, I apologize.
No.
Thank you. Mr. Premier, is it not simply this? We are sitting here where Mr. Carrim has not appeared, contrary to a ruling that he must appear today. And that ruling had behind it that he would be excused if we get an independent medical report that says he's not good to testify. We're sitting in a place where we don't have that medical report, and therefore there's no basis for us to say he is properly excused not to be here. Aren't we sitting with there is no satisfactory explanation, therefore, for his non-appearance? And then, because our rules do deal with such matters, if a witness is required to appear and they do not provide a satisfactory explanation, certain consequences would follow. Isn't it simply that we're sitting where we do not have a satisfactory explanation because of the issues that you have been ventilating with the chair, but the bottom line of it is that which was prescribed as a basis to excuse him has not been complied with. Therefore, we do not have a satisfactory explanation, and we must deal with it in accordance with our rules. Is it not that simple, really?
Well, I think the danger in characterizing it as being that simple, Commissioner Baloyi, with all due respect, is that then a reading subject to my caveat.
Well, we're not deciding. The Commission is not deciding mens rea.
Yes, indeed.
And we're never in a position to do that.
Indeed.
So leave that out of the equation. All I'm saying is we have his doctor's report. You've had the concerns of the Commission about this doctor's report. There was a ruling to try and resolve the issue. That has not materialized.
Yes.
We sit at a place where he's not here. The Commission is not prepared to accept the doctor's report. You've had the engagement with the chair for reasons that have been given. We end at, well, we don't have an explanation, a satisfactory explanation for his absence. Someone else will determine whether he did have a reasonable, a satisfactory explanation for not appearing. And that's a different process from ours. What we do in terms of rules is to say, on the material before us, he hasn't provided a satisfactory explanation for his absence. And let somebody else evaluate whether that constitutes a criminal offense or not.
Now, I think you and I are ad idem on the mens rea and the willfulness point, but when you are sitting, you on bank as the commissioners, are sitting qua commission and are applying your mind as to do we lay the charge for the strict non-compliance of the order as directed. All I'm saying is that one of the factors you'll have to take into consideration as to whether or not to lay the charge is that there is evidence in front of you that suggests that a charge may be inappropriate for the reasons contained in the medical report. Say that that's where my concern and challenge comes about the rationality of such a decision or determination in the circumstances because of the available evidence in front of you. It's that DA versus President Simelane type of scenario that I'm postulating.
The other way of treating your doctor's report and all the evidence, by the way, not just the doctor's report, everything that has been placed before us about his non-appearance over time. Another way of treating it is to say, we've looked at all of that.
Indeed.
We are not satisfied that it provides a satisfactory explanation for his appearance. So it's not simply we closed our eyes as if those are the only things we could do. Is to look at all the material and say, on all of this, we are not satisfied that there is a satisfactory explanation for his absence.
Yes.
And on that basis, we refer.
Yes. Well, I think, Commissioner Baloy, if that's what the Commission does, though, because then all the evidence is being considered in the basket of factors, shall we say, before the charge is laid or not laid, then that's procedural rationality met. It means that you follow the correct evidential consideration decision-making process. And I don't disagree with that. A question of substantive rationality.
Trust us to do that.
Yes, no, I've never not trusted.
And it's the Audi. And I was glad to hear that Mr. Premier was finding a way to walk down the hill. But then as he went on, I thought he started to climb up that hill again that he said he didn't want to die on. And I just want to say one thing in respect of that. I mean, it's tempting to go to other things, but it is in relation to the laying of the charge. This is, in my view, and I want to urge the Commission to do so, because the reason for doing so, and let me firstly say, it's not a decision by the Commission. It is the laying of a complaint. And even if that complaint were framed as to the SAPS, we recommend that you charge this person for the following. What will the SAPS do with your recommendation with respect? It's not a binding recommendation. The SAPS will say to you, thank you very much for your view. We will do our job and we will take it from here. So it is in the hands of the relevant authority to do with that whatever it wishes to do with that. And that must play out. That's the first thing I want to say. The second thing I'd like to say is that it's important that the Commission does so. Because not only does the Commission have the power to regulate its own processes, it has a duty to protect its processes. And it's important for the protection of this Commission's processes that takes place. The context in which this particular, what we call a breach of the Commissions Act has occurred is the context that I can't go into detail on, but it is why the postponement application became so substantive and why the medical expert report was required, was why it is necessary, important, and of value in this particular context for the patient himself to be examined. So the constant sort of tender for us to talk to the treating doctor doesn't help. So that's the context in which we come across, we find ourselves here. And my submission is not only would it not be a decision that now is subject to some further audi, because it's a complaint, it will follow its course. The Commission is not making any decision regarding intention, willfulness, etc. The second thing is that, in my view, and my submission to the Commission is that I urge you to do so because it's necessary to protect our processes. Thank you, Chair.
Thank you, thank you. I doubt that you would want to say anything to that.
I'm covered.
Thank you very much. As I indicated, at least then I said the Commission was minded to. Let me outright say the Commission is going to set the criminal process in motion. The Commission will direct the relevant functionary, and as you anticipated it, Mr. Premhid, that functionary will be Dr. Vuguza sitting across there, who is the Commission Secretary, and for her to lay a criminal charge, not to make a recommendation, to lay a criminal charge against Mr. Carrim. If the Commission were not to do that, it would itself not be taking its processes seriously. This is something that the Commission just has to do. Otherwise, witnesses will choose to come or not to come testify before it willy-nilly. And we cannot and we will not have that. So the Commission will lay criminal charges against Mr. Carrim. Whether he has defenses to that, that's something for him to raise in that criminal process. Thank you. I will not even say that this is what the sort of decision that one usually has in mind in the context of decisions that are taken and which are reviewable. But of course, I can never stop Mr. Carrim taking us on review on this. But I would be very surprised if he were to do that. I'm just announcing what the commission is minded to do. I have a note. I will do a trump on my colleagues. Both of them have sent me notes. Oh, two issues. One is that's the end of the road